raised on country sunshine on a farm in Tennessee. He'll be great for the volunteer state and people like you and me. He's a man of all the people. He'll treat us fair and equal. We need a ray of Blanton sunshine.
We appreciate your kind attention to all of this. I failed to point out when I was doing my thank yous earlier, arguably one of the most important, if not the most important, components of our presentation was the Federal Court Library Fund, which now for the third time has financed this operation. And even though, yes, very good. Even though all of the time of our participants is donated, and therefore hundreds of hours of time is not being billed at Bone McAllister, Lynch Law Firm, and other places where surely it ought to be. The Library Fund has been very generous with us, and Judge Campbell has had a lot to do with that. He was present for our first two programs, and we appreciate him and all of the judges who had to approve that, obviously. Okay, let's move right along here. We're now going to what's called liquor for sale. Don't leave. The presenters on this are retired judge, appellate judge, and Chancellor Ben Cantrell, known very well to all of you. Bob Lynch Jr., Bob Lynch Law, who was an assistant United States attorney, and along with United States District Court Judge Aleta Trauger, did the trial prosecution of the governor himself and two of his aides. So they have divided their program up, much as the previous group did, and I will invite Judge Cantrell to come to the microphone and give you the history of this very interesting tale about demon rum.
Well, the history of the attempt to control the sale of alcohol in Tennessee would fill several volumes. We don't have time to go through much of that, but some of it is fascinating. First, when Nashville was a frontier village, apparently it was not considered sinful to manufacture spirits. One of the leading pastors in Nashville in the late 18th century had a licensed still on Gallatin Pike. That was probably while this was still part of North Carolina, and the control of the sale of liquor was strictly a local option. The county clerk at that time had the power to issue a liquor license. But in the 1820s, a great revival swept across the frontier, and Prohibition began to be preached from brush arbors and camp meetings to city pulpits and all Protestant seminaries, as if sin could be wiped out just by making alcohol illegal. The struggle in Tennessee continued into the 20th century and resulted in the rupture of the Democratic Party after the 1908 Democratic primary. The wet candidate, incumbent Governor Ham Patterson, defeated the dry candidate, former Senator Edward Ward Carmack. Carmack returned to Nashville from Memphis after the primary and became the editor of the Tennessean. His editorials ridiculing Governor Patterson and one of his major supporters, Colonel Duncan Cooper, led to a confrontation on 7th Avenue in Nashville on a November day in 1908. In the ensuing gunfight, Carmack was killed. Now, Colonel Cooper and his son Robin were both indicted and convicted of second-degree murder. They appealed, and in a long opinion by the Supreme Court of Tennessee, which you should get and read just for the history of what was going on at that time, the Supreme Court gave Robin a new trial but affirmed the conviction of Colonel Cooper. And in an act foreshadowing what happened that you heard from David and Bill, Governor Patterson, as the Supreme Court was reading its opinion affirming the conviction of Colonel Cooper, issued him a pardon. before they were through. Well, the resulting outrage split the Democratic Party even further, and a Republican, Ben Hooper from Newport, was elected governor in 1910. The first act passed by the General Assembly in 1911 effectively made Tennessee a dry state. Don't ask me to explain the 4 Mile Law, but that was the device used to prohibit the sale of evil spirits. Well, 5 years later, the whole country followed suit with the passage of the 18th Amendment, and the country struggled through until the passage of the 21st Amendment in December of 1933. But the effect of the repeal of Prohibition on Tennessee was not immediate. The state remained a dry state until 1939, when the state passed a law making the sale of alcohol again a local option. For a short explanation of all of the development of all that, you should read Bill Koch's brief in the Supreme Court in the Shacklet case. We'll talk about Shacklet a little more in a minute, but Assistant Attorney General Koch said, and I'm paraphrasing some, the effect of the legislative action and the decisions of the Supreme Court since 1939 demonstrate that the legislature has determined that the state's police power to regulate the traffic in alcoholic beverages should no longer be delegated to the whim of the various local authorities, but should rest in a single centralized state agency charged with the sole responsibility of administering a uniform system of laws of statewide application. The agency designated by the legislature to administer the law was the Commissioner of Finance and Administration. The agency was the Department of the Finance and Administration. But the law still gave a small role to the local governments, where the applicant had to get a certificate of good moral character from the local government. So local authorities didn't give up. They still wanted to keep the power to say where a liquor store could be located and who could run it. For instance, in Nashville, a local ordinance restricted the sale of liquor to an area inside what they call the restricted zone, which was the area inside the old city limits of Nashville at some date before the adoption of the metropolitan government. The way the city controlled the location to that area was simply to deny a certificate of good moral character to anyone who wished to locate a liquor store outside the zone. The city of Chattanooga had a similar ordinance that restricted the location of liquor stores to some arbitrary area in downtown Chattanooga. So in 1975, the Tennessee Supreme Court took a case where the city of Chattanooga had denied a certificate of good moral character to a man named Posey, who had a liquor store in downtown Chattanooga on Rossville Avenue. But he wanted to move the store north of the river on Hickson Pike, outside of the restricted area. Well, as could be predicted, the city wouldn't give him a certificate of good moral character. So he appealed to the ABC, which went ahead and granted him a license anyway. The Supreme Court finally took the case and affirmed the ABC in an opinion found at 525 Southwest 2nd, 470, an opinion that effectively broke the power of local governments to arbitrarily control the location of liquor stores in their jurisdictions. Justice Henry wrote the majority opinion, and in his customarily vivid style, he said, "The strange notion that a person's good moral character is somehow keyed to the location of his business is at variance with logic and frustrates the English language. In this particular case, it is incredible that there is an insistence that Mr. Posey is unquestionably a man of good moral character so long as he does business on Rossville Avenue in downtown, But when he changes his business location, he loses his morality ipso facto and becomes a heathen on Hickson Pike. This is sheer sophism and legal gimmickry, and is the type of reasoning that causes citizens to sneer at the law and scoff at the courts. Well, obviously, the power had been now vested in the ABC, making it a real fertile ground to be tilled for political advantage, just as a new regime rode into town after the 1974 election. So after the Supreme Court's opinion in the city of Chattanooga, the deluge began in Nashville. The next day, literally, a merchant petitioned the ABC to let him locate a store in Green Hills. Within a short while, there were 39 applications for locations outside the old restricted area in Davidson County. Some of the names you've heard before and may hear again: Jim Allen, Ed Hood, Jack Ham, were all participants in what was going on in the ABC. You will hear more about them in a few minutes, and how the ABC was manipulated by persons close to Governor Blanton. Judge Tom Wiseman, then a practicing lawyer, represented 3 of the applicants, and he remembers that the word on the street was that you had to go see Gene Blanton, the governor's brother. Judge Wiseman had 3 applicants, and he didn't go see Gene, but he was successful anyway in getting the ABC to issue his clients a license. The ABC ultimately approved 12 new stores and denied the applications of 9 others. As a trial judge in Davidson County, I had to hear the appeal of the metropolitan government concerning the 12 that had been granted, and consolidated with that were the appeals of 7 of the 9 who had been denied. The case was appealed to the Supreme Court and resulted in the 1977 opinion in the Metropolitan Government of Nashville and Davidson County versus Earl C. Shacklett, Jr., found at 554 Southwest 2nd, 601. I, as a trial judge, affirmed the 12 granted applications and ordered the ABC to grant the 7 applicants who'd been denied because the record didn't show any basis for the distinctions made by the ABC. Well, the Supreme Court thought that my opinion on the denials was a little far-fetched and remanded them to the ABC for the agency to make findings of fact and conclusions of law. And not until we started this program, reviewing it, did I understand what the basis for the denials was. On the 12 that were granted, one of Blanton's people had gone to the ABC and just marked an X by each of those 12 and said, those are the ones that are going to be granted. I don't know what happened to the 7 after that, but hopefully they finally got a hearing anyway. So the stage was set now for what happened next, and you're about to hear that. So I turn it over to my colleagues.
My name is Bob Lynch, and I had the great opportunity to be hired by Hal Hardin to work in the Middle District of Tennessee, the U.S. Attorney's Office. There's a lot of ironies that you all have heard, I believe, concerning the Blanton era. But one irony, and the first irony, I believe, is in 1977, Hal Hardin, who had been appointed to be a circuit judge by Ray Blanton, was appointed as the U.S. Attorney for the Middle District of Tennessee. I think he had 10 assistants, and the number of prosecutions, and we're talking about the Blanton, but there were a lot of public corruption prosecutions that Howe himself was involved in. But because he was appointed by Ray Blanton, he had to recuse himself from prosecuting Mr. Blanton, or at least investigating him. So that fell to the Joe Brown, who you all have seen today, who talked about it. And back in that era, it was common practice for new U.S. attorneys, when they were appointed, to fire all the existing staff. U.S. Attorney Hal Hardin recognized that Joe Brown was a too valuable person to fire or dismiss, and he kept him on. And it was Joe Brown, because of his recusal, who directed the investigation and prosecution of the members of the Blanton administration. Now, although Brown successfully, I believe, dismantled the Blanton criminal machine, as I call it, and you've heard about that up to this point, Ray Blanton himself remained untouched by these investigations. So, Joe Brown, utilizing a tactic that the U.S. Justice Department used to investigate and convict Al Capone for tax evasion, he enlisted the aid of two crack IRS investigators, Ed Campbell and Charles Eckerslude, who is now deceased, to investigate Blanton, who, according to some sources, was the fourth most corrupt politician in U.S. history. Now, when I use the term Al Capone, that's not a joke. There was a lot, if you remember the Al Capone, a lot of activity going on about him, but he always remained above it. And a lot of people still believe that Ray Blanton was actually convicted on the pardons and paroles, but that's not what happened. It was the liquor license that formed the basis for his conviction. Now, Campbell's, and by the way, my function here is to sort of lead up to the trial. Judge Trauger will give you the real facts, I suppose, of the investigations as it was brought out at trial. But Campbell's and Eckerslude's investigation led to a man named Jack Hem, who was a close associate of Ray Blanton and who had received a liquor license for a liquor store in Donaldson, Tennessee. Now, their investigation revealed that Jack Hem was not right with his taxes and thus was subject to federal prosecution for tax evasion. Jack Ham was represented by a great Nashville attorney, George Barrett, who's everybody knows George. Unfortunately, he's passed, but he was a great lawyer. But he had a lot of bargaining position here because there he is up there. That's Jack Ham right beside him. But as you all know, George, if he had an opportunity, he would exploit a case to the max, and he did in this case. He had a lot of leverage, if you will, because Jack Ham was the only person that we were able, U.S. Attorney's Office, able to have a one-on-one conversation about a criminal act. We didn't have that from anyone else. Jack Ham was all we had. Now, so he cut a deal where Mr. Barrett cut a deal where Ham would have complete immunity and he would keep his liquor store. I think you all would imagine that that's a pretty good deal. And it came back to haunt us quite a bit, by the way. But in any event, the essential, and Judge Trauger will get into this in more detail, but the essential thing was that Jack Ham, there was a young associate, one of the co-defendants in this case, Ed Hood, who they wanted to get these liquor stores because of the case that was mentioned. But Ed Hood didn't want Ray Blanton to know that he was involved, so he was always on the outside with respect. That's why he couldn't give us any information directly. But Ham said he had a meeting with Blanton where Blanton agreed to give him and others 20% of the profits of these liquor stores when these licenses were granted by the ABC. Now well, like all cases, this one had a problem. Jack Ham was supposedly very ill, and he was expected to die at any time. Therefore, Judge Trauger and I were under intense pressure to fully investigate the case, present it to a grand jury, and immediately seek to preserve the testimony of Jack Ham by deposition to use at trial in case he died or was too sick to show up. And without him, of course, we had no case. So we had a lot of anxiety about that. So Judge Trauger and I literally spent days at Ham's residence going through all of the facts of the case. We kept sending the IRS agents out to investigate, and we developed the case as best we could with the understanding that we would always go back and do further investigation, because what we lacked was what was going on in the ABC. We just had Ham's testimony. Now, as you can see, on October 30th, 1980, the grand jury indicted, or we presented the case of Ray Blanton to the grand jury, and they indicted him, Clyde Ed Hood, and Jim Allen. Now, Ed Hood was a young man who was literally worked, he was like his assistant, Blanton's assistant, and Jim Allen had been the one of his campaign managers in East Tennessee. Now, November the 6th, 1980, Ray Blanton turned himself in, and he was represented by Kingsport attorney John McClellan, who was a colorful character, I'll say. Now, what's interesting about this picture, if you look over in the right there, you'll see a young Marsh Nichols. At that time, Marsh was a reporter for the Nashville Banner. I don't know if she's here, but certainly you all know her now as the court administrator. Ed Hood was represented by Bill Willis, a then very prominent lawyer in Nashville. I'm sure you all have worked with him, most of you, or a lot of you. And his associate at the time was Bob Delaney, who is still practicing, a very good lawyer. And James Allen was represented by Tyree Harris Jr. and his son, Tyree Harris III, who still practices here in Nashville. Now, we indicted the case on November 6, 1980, and the very next day, we moved the court. At that time, the judge was Judge Peck, who was in Cincinnati, and we moved the court immediately for a deposition of Jack Ham, which he granted, and then we proceeded literally within days to take that deposition. As you can imagine, the defense filed many pretrial motions, which we felt were done to delay the process. Obviously, they weren't dumb. They knew that if Ham died or was not available before this deposition was secured, we had no case. So they filed all kinds of motions. They objected to the out-of-court deposition in and of itself. There was severance motions filed. All defense lawyers filed motions for Ham's tax records and his grand jury testimony. They objected to everything, where it was held, the fact that it was private rather than public. They wanted it in a courtroom, I guess with a judge there. Ham's lawyer, George Barrett, he sought to disqualify Ed Hood's lawyer, Bill Willis. I mean, these things were back and forth everywhere. And just the weekend before the deposition started, all the media filed motions to open it to the public. We ended up having to go to Sixth Circuit that weekend in an emergency session. They permitted us to go forward the next day. So it started on December 5th, 1980. And we started the first day And as you can see, the next day, everything that Jack Ham had said during the deposition, which was supposed to be private, was on the front page of the Nashville Tennessean. And when you see Ham details meetings with Blanton, that's exactly what he did. They had questions and answers. So we never knew who was leaking that, but somebody obviously was leaking it. And they didn't leak it, by the way, favorable to the government. It was very favorable to the defendants. Now, this deposition covered over 16 days with over 40 hours of testimony. Didn't end until January 6 of 1981. Judge Trauger will tell you about his testimony because that's what was played at trial. But again, we were getting motions. Every day there was some new motion which we were having to respond to and deal with Jack Ham, by the way, because he was very difficult to deal with. In fact, he had the right, if he wanted to, because of his doctor, to stop. He could say, I don't feel good, I want to stop. Sometimes he didn't even show up. I actually spent a lot of time talking to Ray Blanton because we were all sitting around waiting. And back then, I guess we were a little bit more informal. Bill Willis was there. We weren't talking about the case, but we just generally talked. Found the man to be very charming. It didn't look like he didn't look the same man that was on the interview, but nonetheless, it was an interesting experience for me, waiting for Jack Ham. But in any event, we ultimately got the deposition done. That iron was that was off our back at that point. We didn't have to worry anymore. We knew we could get to a jury. The problem is we didn't have any evidence that corroborated what happened in the ABC, the corruption at the ABC. So the IRS, again, this is not exciting work, but they go through all the files, and in one of the files of a man by the name of Robert Towns, who happened to be the Davidson County patronage chairman, they saw in the file that there was checks written to a guy by the name of Rollins from Fayetteville, Tennessee. And just on a hunch, we thought, well, S.J. King's from Fayetteville, Tennessee. I wonder if there's a connection. The agents went down to Fayetteville. They met with Rollins. I'll never forget the phone call that I got from Ed Campbell when he said, guess what? And I said, what? And he said, this is S.J. King's son-in-law. And of course, then he squealed and told the whole story and whatever, and we got him involved. And then ultimately, S.J. King pled guilty of receiving $85,000 of this money that he shouldn't have gotten because he was the chairman of the ABC, and it was against the law of Tennessee for someone in the ABC to have a liquor license. So that was, we really felt good then because we could corroborate the testimony of Jack Ham, which we certainly needed to do. Now, with his cooperation, on March the 12th, 1981, a federal grand jury superseded this case with the King testimony, and we were ready for trial. And you will now hear Judge Trauger tell you about that trial.
And so on April 15, 1981, the trial begins. Because all of the Nashville judges had recused themselves, Sixth Circuit Court of Appeals Senior Judge John Peck from the Southern District of Ohio presided over the trial as it began. Judge Peck denied the lawyers the right to conduct the voir dire and pick the jury in a day and a half. Jury selection later became a prime issue on appeal, but the en-banc Sixth Circuit decision included in your packet affirmed the adequacy of the jury selection process on the ground that the defendants had been granted additional peremptory challenges, not all of which were used by them, and that the judge's voir dire examination of the jurors, aided by jury questionnaires completed in advance, was sufficient to select an impartial jury despite the massive pretrial publicity of Blanton-era scandals and prosecutions. Bob Lynch delivered a 95-minute opening statement outlining the 11 counts against the defendants, charging conspiracy, mail fraud, and Hobbs Act extortion violations. As the trial got underway, it was anticipated that the government's star and extremely difficult cooperating witness, Jack Ham, would testify in person as ordered by Judge Peck. However, right before the trial, his lawyer, George Barrett, had presented new medical evidence that convinced Judge Peck that Jack Ham's health would be in danger if he were forced to testify live over several days. Therefore, it was decided that Ham's testimony would be presented by the videotaped deposition. So at that point, 40 hours of videotape containing extensive objections and lawyer wrangling had to be edited for trial, which might have been an easier task today than it was in 1981. Before testimony actually began, Judge Peck's wife was hospitalized with a serious health problem, and he had to be replaced by another Sixth Circuit judge. That judge was Bailey Brown, a Harvard Law graduate from Memphis, who had sat on the district court bench in Memphis for some 18 years before he was elevated to the Sixth Circuit. The government's first witness was Bill Koch. You know him as a former Tennessee Supreme Court and Court of Appeals judge and now law school dean. I don't know if he's here today. I haven't seen him. At any rate, Judge Koch had been the Assistant Attorney General assigned to the Alcoholic Beverage Commission during the relevant time period and was Governor Lamar Alexander's personnel commissioner at the time of the trial. He described the process for the issuance of liquor licenses by the state ABC and testified that it violated Tennessee law for a public official to hold an interest in a liquor store, for one person to hold an interest in more than one liquor store in a county, and for an application to not fully disclose the interest of all persons having an interest in a liquor store. The liquor licenses issued to the Friends of the Blanton administration typically violated one or more of these legal requirements. My memory is that Judge Koch was at least mildly uncomfortable being the lead-off witness in this highly publicized prosecution. I even think we had to subpoena him. You might remember that, Bob. However, his personal involvement in the legal developments that led up to new liquor licenses being available in Nashville, as well as his intimate knowledge of the working of the Alcoholic Beverage Commission, made him a perfect set-the-scene witness. Ham's contentious testimony by videotape followed. Ham testified that he and co-defendant Clyde Ed Hood, a special assistant to the governor, agreed to attempt to get 2 liquor stores by paying Governor Blanton 20% of the profits and splitting the remaining profits 50-50. He testified that the governor agreed to this proposition and agreed to keep competition away from the 2 stores. Hood and Ham then went to Bob Frensley, a very politically active Democratic friend of the administration who owned a car dealership, and proposed that he also get a liquor license. They proposed that 80% of his profits be split 3 ways and told Frensley that the additional 20% would be going to Blanton. Frensley, who had been given immunity and was compelled to testify at the trial, later corroborated this meeting and the statement about paying 20% to whom Jack Ham referred to as the man. Hood did not want the governor to know of his interest in the liquor stores, and Ham could not apply for 2 licenses in his own name. So Jack Ham's employee, John Stone, became the applicant for Hood's liquor store. Ham testified that at some later point, he was summoned to the governor's office where Governor Blanton told him he was getting too much and that he was only going to get 1 store. Hood later told Ham that Jim Allen, special assistant to the governor for the first 6 months of the Blanton administration, and as you've heard, political friend from East Tennessee, was taking over the liquor store licensing, and that both he and Allen would get a cut of all the new liquor stores. Blanton even told Jim Allen to go see then-Mayor Richard Fulton to see if he had any friends who wanted liquor licenses. Rich Riebling's here. I'm wondering if he remembers this. Mayor Fulton testified at the trial about this visit from Jim Allen, in which Mayor Fulton told Allen he had no interest whatsoever in what he was proposing. There was testimony that Jim Allen also approached Robert Towns, chairman of Blanton's Davidson County Patronage Committee, who had applied for one of the new liquor licenses, and told him that the administration had a lot of people they needed to help through the awarding of these liquor licenses, and that he could assure Towns that he would get his liquor license if he would just accept a partner. Towns then proposed to S.J. King, the then chairman of the Alcoholic Beverage Commission, that King become his 25% partner. King responded, surprise, surprise, that he could not be a partner in one of the liquor stores because he was chairman of the ABC, but that he would arrange for someone to serve as his nominee, making S.J. King a silent partner in that license held in that person's name. That person turned out to be C.S. Rollins, as Bob told you about, who later became S.J. King's son-in-law. Both S.J. King and Robert Towns pled guilty to criminal charges in connection with this scheme. An important witness was Dorothy Mucklow, who had worked at the ABC since its inception. She testified that Ed Hood had come into the ABC office to meet with Lee Hayden, the then director of the ABC, and that Mr. Hayden had asked her for a list of the applicants for the new licenses in Davidson County to take into that meeting. Ms. Mucklow later found on her desk her typed list with X's beside 12 of the names. S.J. King testified at the trial that Director Hayden had shown him a list of the Davidson County applicants with X's marked next to the 12 names that the administration wanted approved for liquor licenses. Although Hayden maintained that he had picked the best applicant at the best location for the license awards, no information was presented to the commission on the hearing day as to why a particular applicant was better qualified or why a particular location was better for any particular license. It was all a sham. Of course, in order to pull off the scheme of awarding liquor licenses to friends, whether or not they were qualified, the defendants needed to have the cooperation of the ABC, whose decisions were determined by a vote of the 3 commissioners. Chairman S.J. King had been appointed by Blanton to the ABC, had a secret interest in a liquor store, and testified that he wanted to be loyal to the administration. Commissioner Frank Phillips, also appointed by Blanton, testified that he went along with the staff's recommendations without reading files or other materials because he assumed they were the administration's wishes and legitimate patronage. The 3rd commissioner, Carl Jones, a newspaper publisher who had been on the Alcoholic Beverage Commission since it was established in 1963, testified that he refused to vote for the list presented to him the night before that meeting because there was no presentation of evidence at the meeting and that evidence at the meeting that these were the best qualified applicants. But the vote of 2-1 carried the day, and the favored 12 got their licenses. The real bombshell hit on May 19th during the 5th week of trial, when proof emerged that Jack Ham was skimming profits from his liquor store, on which he paid no taxes. His nephew, Bert Ham, had testified a few days before, corroborating much of Jack Ham's testimony, but asserting under defense questioning that Jack Ham skimmed profits from his liquor store. We put Bert Ham on the stand knowing that he contended this, but we were unable to determine before trial which Ham, Jack or Bert, was telling the truth about the skimming, and we needed the testimony of both witnesses. What happened after press coverage of Bert's testimony was that an employee of Jack Ham's liquor store contacted the IRS agent working on the case and admitted that he had lied to the agent about Jack Ham's skimming. This launched additional investigation and interviewing of additional witnesses, several of whom corroborated that Jack Ham did maintain 2 cash registers at his liquor store and had skimmed substantial profits without paying taxes on those profits. At that point, we felt that we had to revoke Ham's immunity because a condition of his agreement with the government was that he tell the truth, and he had lied about this issue to agents and in sworn testimony. And I will say, given the contentious relationship with him, we were really pleased to be able to indict him. There was no question that we would indict him. Timing was the only issue. First, we decided that doing so in the middle of the trial was not in any way prejudicial to Jack Ham. Then we thought about the impact such an indictment would have upon the Blanton trial, which was then in its 5th week. We had an obligation under the Brady case to immediately inform the defense attorneys that Jack Ham had lied about the skimming, and we knew that they would figure out a way to bring this development before the jury. We could envision a powerful defense argument that in addition to Jack Ham's sweetheart deal of immunity and keeping his liquor store, we now knew that Jack Ham was a perjurer, and we were going to do nothing about it. We thought that by revoking his immunity and indicting him for the same conspiracy and mail fraud violations presently being tried against Blanton, Hood, and Allen, that we could foreclose those powerful defense arguments. After a lengthy discussion, the judge had us, the prosecutors, inform the jury in simple terms that we had indicted Jack Ham on the liquor license scheme because he had lied about skimming profits from his liquor store and therefore lost his immunity from prosecution. Next came the defense case. Blanton called several department heads under his administration who were allowed to give general favorable testimony about Blanton as a governor, but not to testify to the absence of corruption in their departments, as Blanton had wanted them to testify about. He also called Lee Hayden, director of the ABC, who, unfortunately for Blanton, testified that arrogant, profane, and aggressive Jack Ham told Hayden that he had essentially bought the governor and owned Hayden. Hayden was at that time serving a 3.5-year federal prison sentence for an unrelated extortion conviction in Memphis, and had been given a furlough in order to come and testify at the trial. Defendant Hood called 2 ABC witnesses to testify, and Jim Allen called no additional witnesses. The scene was then set for the testimony of the 3 defendants themselves. Blanton testified for a full day. His demeanor described by the Tennessean as tense at first, then relaxed and confident, and eventually bitter and resentful. The changes were apparently attributable, at least in part, to the fact that Blanton, always a heavy drinker, had had 2 drinks at lunchtime when he was in the midst of testifying. Blanton would claim later that his lawyer was ineffective, in part because he allowed him to drink while he was still on the stand. What perhaps was even more ineffective was the fact that Blanton had not reviewed his grand jury testimony before he testified at the trial, and was repeatedly impeached on the stand by Lynch with his own words to the grand jury. Young Clyde Ed Hood admitted in his testimony that he and Ham had agreed to get 2 liquor stores together, but denied that Blanton was to receive a share of the profits, and maintained that they had planned not to obtain the liquor licenses until after Hood had left the government, so that he could legally own a liquor store. Hood admitted that upon orders from Blanton, he had told the director of the ABC to allow the transfer of Jack Ham's license at some point because the governor had an interest in that happening. However, he denied that he had told King that the governor had a financial interest in Ham's store. Allen's testimony was brief, and Judge Brown dismissed the Hobbs Act extortion charge and some of the mail fraud charges against Allen before the case went to the jury, because he was not a public official at the time of the alleged extortion. My 4-hour closing argument, interrupted several times by the judge who thought the jury had just heard enough, attempted to piece together the testimony of 25 witnesses over 6 weeks of testimony, and to detail the ways in which Jack Ham's testimony had been corroborated by other witnesses, which was especially important given the revocation of his immunity for lying. Luckily, the jury believed enough of Jack Ham's testimony and the testimony of the other witnesses to convict all 3 defendants. Blanton was found guilty on all 11 counts against him. Hood was found guilty of the conspiracy and 6 mail fraud counts, but acquitted on 3 other mail fraud counts and the Hobbs Act extortion count. Allen was found guilty on the conspiracy charge and 6 counts of mail fraud. Blanton was sentenced to 3 years in prison, Hood to 18 months, and Allen to 2 years. They all served their sentences before that Supreme Court decision mentioned by Joe Brown that changed the law of mail fraud. The jury, which was not sequestered, had deliberated for 45 hours over 6 days, often until 9 p.m. The jurors grew very close through this experience, and the press often noted the ways in which this was evident, exchanging looks, passing mints to each other, chuckling at the same time about something. The judge allowed the jurors to be interviewed following the verdict, and one juror said that they all wanted to attend Jack Ham's trial and that she planned to take a day off work to do so. We later learned that the jury had several reunions after the trial. The newspaper coverage had focused a great deal on the jurors, even amazingly featuring a photo of them, I hope we have that one, during deliberation that actually included their names. I do not believe that would be allowed in most jurisdictions these days. The defendants filed a motion for new trial based on the newly discovered evidence that Bob Lynch and I had abused prosecutorial discretion by considering the effect upon the Blanton jury of indicting Ham in the middle of the trial. Judge Brown denied the motion, and the Sixth Circuit, thank goodness, affirmed that ruling in a 3-page opinion. Jack Ham did succeed in having his immunity restored, however. In a separate case filed by him, represented by Jim Sanders in our audience, Judge Morton ruled that we had gotten the benefit of our bargain with him in that all 3 defendants had been convicted based largely on his testimony. So his immunity was restored. Of course, we all thought he was on his deathbed at this time, but he lived for a long time after this. Let me conclude with an anecdote about the times that my co-presenters have urged me to share with you. Remember, this was 1981. There were very few women prosecutors in the state of Tennessee, and Judge Bailey Brown from Memphis had probably never seen one in his years on the district court bench. He was a true Southern gentleman, very bright, no nonsense, and ran a tight ship. I had a great respect for him. However, whenever he summoned the lawyers to his chambers, which during the trial was often, he referred to us as gentlemen. I tolerated this for 3 or 4 weeks without comment, but one day I sort of hung back as we were all leaving his chambers. And after everyone left, I said, Judge Brown, you know, I don't think you realize it, but every time you refer to all the lawyers, you call us gentlemen. And I thought he would jump in and say, oh my goodness, I had no idea I was doing that. I apologize, I'll fix that. Well, that comment was met with silence. So I decided maybe he needed a suggestion. So I said, Judge Brown, you could just call us counsel. Again, silence. So I retreated with my tail between my legs back to the courtroom. The next time Judge Brown addressed all the lawyers in the courtroom, he called us, guess what, gentlemen. Some days later, he did finally begin to address us as counsel, and this page of the transcript holds an honored spot in my memory book. I can't overestimate the effect that this highly publicized prosecution had upon my future as a trial lawyer in Nashville, including being hired by John Hollins 6 years after Ed was hired by him out of the U.S. Attorney's Office, and Ed was still there. We had a small firm. I think it proved to the doubting Thomases who did not believe that women were tough enough to be litigators that we were. And I hope and trust that it benefited other women lawyers practicing at that time, as well as perhaps some of you younger women lawyers here in the room.
Yeah, that was quite a coup for us to be able to hire a lady out of the U.S. Attorney's Office back then, and she unfortunately decided to run off to another state for a little while. We weren't able to keep her, so we had to replace what, in my mind, was one of the best lawyers in Nashville with one not quite as good, a guy named David Rabin, but he stayed for 25 years, so that was great. Thank you very much. We're now going to ask that our panel members come forward, and as they do, I'm going to give them a little extra introduction. The reason we're not doing formal introductions is that the information on all these folks is in your written materials, and we feel like most of them are so well known anyway that you don't need that. But in this case, I'm going to mention that Joe Brown, already familiar to all of you, has been both a prosecutor and is now a judge for many years, and was right in the thick of it, and so we felt like he had to be a part of our panel. To his left is another person well known to you. Judge Daughtry was actually an assistant district attorney in Tom Shriver's office in the early 70s when I got back from Vietnam, and it was her that I distinctly remember standing in a hallway one day who suggested to Tom Shriver that he give me a job after I graduated from Vanderbilt, so I'll always have a soft spot in my heart for Judge Daughtry. She went on to be on the Tennessee Court of Criminal Appeals, the Tennessee Supreme Court, and a judge for the Sixth Circuit Court of Appeals in Cincinnati. And so she was all around this, and as you'll hear in a moment, had a particular job to do for Governor Blanton. Then over there to the other side, there's so much that I could say about Hal Hardin. Much of it would probably get me sued, even though it would be true. But he was grand jury officer in the Tom Shriver DA's office in 1968 when I first went there, before I got drafted. And he and I did some undercover investigations for General Shriver. And then later on, as you know, he became an assistant DA, then a private lawyer in the Norman Law Office, then a circuit court judge for the Second Circuit of Davidson County, United States Attorney for Middle District of Tennessee, where he, even though recused, was involved in a lot of these cases. And now is still practicing law over there on the second floor of the Stallman Building. And the Stallman Building is home to what kind of lawyer?
A Stallman Building lawyer.
No.
Stallman Building hacks.
Hacks, that's it, yes. Famously, in the DA's race in 1974, Tom Shriver, our former boss, stated that Sam Wallace was just a Stallman Building hack, and said that on the radio. And so ever since then, we've referred to Hal as the Stallman Building hack, and he wears that as a badge of honor. All right, I've got a few questions. I'm going to let the panel have quite a bit of latitude here, but I've also got something that I think will add to this. I hope it will. We realized as we were putting this together that many of our presenters, as you've probably noticed, are former prosecutors, judges, maybe even prosecutors now, but people who were presenting primarily the government side of these cases. Now, obviously, I'm an exception to that because I've told you about the Eddie Shaw case. But because we felt a particular responsibility to be even-handed on this, we did video interviews with Eddie Sisk. You've already seen one of those, and Eddie's with us today, and I really appreciate him coming and assisting us with this. But we also did an interview by video of Gordon Ball, a really fine trial lawyer from Knoxville, formerly Newport, Tennessee, who represented Charlie Benson in the one acquittal that occurred at trial in the federal prosecutions. And you've heard a little bit about that, but not much. Now, we asked Gordon Ball to be present for this, but he literally had a change of heart. The ones that are laughing are the ones that know him because he had a heart transplant 2 days after we interviewed him down at the Omni Hotel. And so he's actually in fine shape, got a 22-year-old heart now, but because of the need to not be exposed to any germs, and knowing that many of you carry an outrageous number of germs, he declined to be, actually his wife declined for him to be here today, but we do have him on video, and I hope I can play a couple of clips so that we can get a little bit of the perspective from Charlie Benson, because after all, he was found not guilty. Judge Daughtry, let me start with you. You were asked to play a role right after Governor Blanton's election to be on a blue ribbon panel to help him fill the positions in his administration. Would you mind telling us a little bit about that? And along the way, I think you have some information to give us about the job that Eddie Shaw got.
Yes, in fact, it was an 8-member panel that Chancellor Roy Nix headed up. I was never quite sure how I became the token woman on the panel, but now that I've heard the story about John Siegenthaler being out at the governor's residence, I'm beginning to, the picture is becoming clearer in my head. And there were tokens there. Washington Butler, a council member from Memphis, was the token African-American person. Jim Neely, who was connected with the AFL-CIO here in Tennessee, was the token labor person, and it went on in that fashion. But there weren't any FOR, Friends of Ray, on that 8-member committee. And we were charged with interviewing people who were interested in cabinet positions and sending the name of the person we thought that was the most qualified, possibly even 2 or 3 names for each cabinet office. And we were charged with doing it quickly. The governor wanted something in place fairly quickly, and as I recall, we may have even started meeting in December before he was inaugurated in January. And we did the whole job in 30 days, which was a pretty quick transition from what we see going on now. We sent him names for every cabinet position, and he picked the people that we sent him on every occasion except one. And he came back on the Department of Transportation saying that he was not satisfied with the person or persons' names that we had sent. And I can't remember exactly who came in with the word that who he wanted was Eddie Shaw. And we had Mr. Shaw's resume in front of us. He was basically a catfish restaurant person. I mean, that's basically what he was.
And a very good one.
Yeah, granted. But he was not, for example, a road builder. At that time, he had no connection with Blanton's B&B operations. We did realize that he was very close to the governor. And of course, from the governor's point of view, I gather that knowing something about transportation was not really, in that case, what he was looking for. And so it went back and forth. I heard, I think you were the one that talked about the story that was given by Eddie Shaw's son about how he was it was the last remaining position that hadn't been filled on the cabinet. And I am here to tell you that is the reason, because the governor was resisting our intransigence at sending him Eddie Shaw's name. And the upshot was that finally he just appointed Shaw without our approval. Wasn't anything that could be done about it. But that is an interesting story, not only because it sheds some light on Eddie Shaw and how he got into the cabinet, but also because there was some comment made today about Blanton wanting to be surrounded by his friends, including in the cabinet. And the truth is that was not the case, at least at the beginning. At least at the beginning, it was an open It wasn't exactly transparent because the public wasn't in there when we were voting on which names to send. But there was no, except for Eddie Shaw, there was no under-the-table kind of thing going on in there. I'm here and still alive and ready to make that statement. So,
all right. I want to, Jody, if we can we pull up video number 1 for Eddie Sisk, and I want to show the panel this very short clip and then ask you a question about it.
Ray Blanton had a real feeling for the common man. Ray Blanton had a real feeling for trying to advance the common good. But Ray Blanton had some personal habits that people found very not very likable. And Ray Blanton also had problems with the press, and he was almost insulting when it came to the press, and I think that's what got him in trouble.
Okay, Hal, you obviously knew the governor. You were appointed to the bench by him. You agree with what Eddie just said?
I agree with a lot of what Eddie said. He was that way. He did have some major flaws, and towards the end of his administration, he really, and I think Eddie would say this, was drinking heavily. I mean, he wasn't coming into the office until like 10 o'clock in the morning. But I didn't know, I didn't support Governor Blanton, and I had no idea that I was going to be a judge a week before I was asked to be a judge. And that was shortly after he was sworn in. So I didn't know him prior to that time.
Yep. You agree with the statement that he was a friend of the common man, or had a belief in that?
No, I think he had a core value of being from poor West Tennessee, and I think he had an affinity for the working man. Yes, I do.
Judge Daughtry, you had a...
Yeah, I was going to say, eventually, Ray Blanton got back at the press. I don't know how many people here know that it started back, at least in Buford Ellington's day. There was always a Christmas party given at the residence to which the press was invited, and their spouses, in those days mostly wives. And the last Christmas that Governor Blanton was in office, the press all went out expecting to find large bowls of iced shrimp and plenty to drink, and there was no alcohol anywhere in the residence. Now, I'm sure that there was a stash for the governor somewhere, but they did not. It was a dry party, and I'm telling you, people laughed like crazy and left early, and that was exactly his point, I think.
Okay. Now, you've got a story about the governor's residence, but I want to get Joe in on this conversation. Joe, this business about making the deal to allow Sisk and I believe it was Taylor to plead, but not conditioned on testimony against Benson. Many in the audience that do criminal defense might be looking at that and wondering how that would happen. Tell us a little bit about the analysis that went into that.
The deal had nothing to do with not testifying against Benson. The deal was that they would cooperate and testify. The problem is when we interviewed them, we didn't believe what they said, and we didn't feel like we could use them. There was no deal they wouldn't testify against Benson. Mm-hmm. It's just when we debriefed them, they gave us, frankly, what we thought was bad information. Taylor tried to, as I say, take
Let me elaborate on that. In today's practice, we would do what's known as a proffer, and you would hear what they would have said, and you would have judged that and decided whether to make the deal. Apparently, that was not done back in those days. Is that it?
No, it was done in those days, but the problem was Judge Churchill had announced that he would take no pleas after the trial began. We were right up to the trial, and all of a sudden we were approached with these deals literally at the last day or a couple of days before, and so we didn't have time to do a full proffer. Had we done it, we would have said, no, we're going to trial with them, and we'd have tried all three of them together. I still wake up at night thinking about a few things and a couple of witnesses I didn't call on that case. But no, that was just a time frame, and we didn't have time to do it. Otherwise, we would have.
Okay. Now, Judge Daughtry, you had an occasion to be out at the governor's residence on another event, and tell us a little bit about that and the roller coaster of emotions that you had that night.
Well, I hope we'll get a chance to talk about Ray Blanton's judicial appointments, because there 2 out of the 3 people sitting here at this table were actually appointed to a judicial office by Ray Blanton.
Yeah, and I will say, we never had any evidence that there was any impropriety with the judicial appointment.
Yeah, it may be I should.
Yeah, that's very comforting.
Thank you.
Yeah.
Well, all right, so now that statement
And
has
just in
been
case you're
made,
wondering, we did do a proffer on all the panel members before.
the truth of the matter is that Ray Blanton, among his friends, there were absolutely no lawyers, or at least no lawyers who wanted to be a judge. And so he was just sort of clueless about judicial appointments, and he listened to other people. He listened to some of the big-name lawyers in Nashville. He had Bill on his commission, the Appellate Nominating Commission. So there never was any, there never was any whiff of scandal. I've spent a couple of days this week going over who he actually appointed, and I don't see anybody that was ever held up to any question about it. Now, some of us have been a little nervous over the years to say that when, you're always asked, well, who appointed you? And some of us are put in the position of saying, well, it was the governor of Tennessee who later went to federal prison. But,
Well, now, I've had to say for years that I was appointed by President Bush, and in this town, that didn't get me much.
Yeah. So anyway, the night that I appeared before the Appellate Court Nominating Commission or Selection Commission, I was one of 3 names that was sent to the governor, and in due time, I got a call from his office inviting Larry and me to go out to the governor's residence for dinner. And we were hopeful that this meant that he was going to get us out there and maybe provide us with a beer and say, I'd like you to be a member of the Court of Criminal Appeals. So we show up for dinner and discover to our amazement that we're not eating in the dining room. We're, in effect, eating in the kitchen. And it was a little breakfast room type room that was right there open to the kitchen. And the thing that nearly drove me out of the residence before any kind of conversation about the judgeship could start was the fact that he brought all the kitchen help out and lined them up and made them introduce themselves. And in fact, they were all murderers, as we've heard. And I'm beginning to slide under the table, very concerned that one of them might be somebody that I had sent out to the state prison when I was in the district attorney's office. Fortunately, it was very embarrassing. To them, it was hugely condescending. But fortunately, there wasn't anybody in the group that I knew personally. And finally, after all of that and dessert, he finally did get around to saying that he'd like to appoint me to the court.
Now, when he did that, you remember the exact conversation.
Yeah, he started out by saying, in this position, I get to make a lot of appointments, but I also have to disappoint a lot of people. And I think Larry and I both thought, this is it. He's getting back at Larry Daughtry, and he is going to say, and I'm sorry to disappoint you, but now that you've eaten, you can leave. But in truth, what he said was that he would like to appoint me to the court. We found out much later that in Blanton's sort of twisted way of thinking, he thought this would quote, bring Larry around, unquote, and that he wouldn't have any
Okay.
more trouble from that Tennessean reporter, which of course was a daydream.
He didn't know Larry Daughtry very well.
No, he didn't.
All right, Joe, going to go back to you now for a moment, and Jody, if we can pull up the Gordon Ball video that I think you have labeled verdict, but it's really not the verdict, but.
We got into final argument. Hank puts this in his book, and Hank was very kind to me in his book. And Charlie and I had been together for 12 weeks. It seemed like forever. And I was just worn out. And we get down to the end of my final argument, and the government, Bill Cohen had stood up in opening and said that the government, this was like a football game, and the government was going to show the jury the first half, and then I would argue, and then the government was going to show them the second half. And so I get to the end of my argument, and I said to the jury, I said, you know, this is not a football game. And I had brought Charlie's kids into the courtroom, and they were like 10 and 12 years old. A little redheaded boy and a little beautiful blonde daughter. And I said, it's Alicia Benson's life. It's Chuck Benson's life. It's Marilyn Benson's life. And it's my friend's life. And for the first time, I lost it. I mean, I truly did. I started crying. And I didn't mean to. I was just exhausted. And I turned around, and Charlie was crying. And I looked on the front row. And at that point in time, it was just all reporters. And it was packed with reporters. And they were crying. And I walked over and put my hand on Charlie's shoulder. And that's the way we ended the trial.
Okay.
Jury goes out, and they stay for about a day and a half.
I think we can cut it there. I think he goes on to tell them more about the jury selection. But, I know we showed that to you at one of the meetings, and you and Bill didn't really recall that particular part of it. But can you give us any kind of a postmortem on the Benson trial from the prosecutor's perspective?
Yeah, I thought we had a strong case, and I don't remember that argument, and obviously the way he's arguing, you certainly wouldn't get to be able to make that argument in front of a jury now, going into the punishment like that. We had, I thought, a pretty good case. We had problems. We lost two of our witnesses that would have provided testimony of Benson, Pettyjohn and Anglin. There was another witness that had overheard a conversation at the Flaming Steer, a restaurant on West End, that overheard that Benson was in a conversation with a guy that was making payments. And that guy, we finally found out who it was. It took us a long time to find out who it was. And he had more convictions and problems with, he was into the bingo. If you recall, we had all the bingo and gambling going on back then. And that's probably, if I had to do it over, and again, there's a couple of cases I still wake up once in a while thinking about. We kicked it around and finally decided that he was more of a risk to call than not. Now, I've always regretted not calling him because he could have provided maybe what the jurors said they wanted a little more, could have provided it. But I thought we had a strong case. Gordon was a good lawyer. In fact, after the trial, he hired Benson. As far as I know, Benson worked for him for the next, till he retired.
Working off the fee.
Yeah.
Yeah.
And so, as I say, I thought we had a good case. Gordon did a good job, no question about it. And, that's the jury system.
And not trying to necessarily take your side here, but in defense a little bit, you pointed out you had very little time to reconstruct your case without the two defendants against whom you had additional proof.
We had a lot more, we had a lot of really solid evidence against both, certainly Taylor. I mean, Taylor, we had him, you know.
You had tape recordings.
Absolute, and video. I mean, this was, of course, back in those days, you don't have all the technology, but the Bureau had a camera in the TV. And so they, you know, they'd be sitting there and you could kind of hear the talk show or soap opera going on, but they were recording and they were, you know, they were laying out exact of who they were paying and how bad this guy was. And, well, he's got 40 years. Oh, that's no problem. You know, and so we had really good evidence there. There was one part of the telephone conversation where under the wiretap statute, the way it was interpreted then, you only could use it when you had a consenting party there. And Baldwin at one point stepped out of the room, and Taylor had a conversation with Benson in which they were talking about getting these pardons that he ended up with on the airport. And unfortunately, we couldn't play that part of it because we knew he was talking to Benson, but we couldn't play that part of Taylor saying, you know, my man, this is what we need. This is what, can you bring it down here? We couldn't play that, and we could have probably called Taylor, but Taylor was just, I mean, he was all over the place. At one point, he said, for complete immunity, I can give you 113 people in the administration. And, you know, at that point, we'd had enough of Taylor.
Now, Hal, you've been trying cases almost 50 years, and we need to have a light moment every once in a while on one of these. So, Jody, if you wouldn't mind playing CIS number 5.
This is not part of the legal record, Eddie, but the first time we met, we were spending the entire day. It was on a Saturday, I think. We walked out on the sidewalk and a pigeon crapped all over Eddie's suit jacket, and I took this as a bad omen.
Some days you're the statue and some days you're the pigeon.
So some days you're the statue and some days you're the pigeon. Ever had any bad omens?
I can't think of any right now. I'm sure there have been.
Might have been some in the Powell case.
Well, there was. I guess the Powell case was my first loss, my first trial, 1968.
Yeah.
The only bad omen I remember from the Powell case was I was convinced that Powell was going to be convicted, and I was feeling sorry for the Powell family that I'd gotten to know over how many weeks it was in the trial. And as a jury was coming in, I was thinking, well, I feel so badly about these Powell children that are going to have to listen to a jury say that their daddy is guilty of first-degree murder. And I remember Mrs. Chastain was her name. She was one of the jurors. She walked in and she looked over at Bill Powell and she smiled. So I guess that was a foreshadowing of what was to come.
Now, see, you had to think a minute, but there's your bad omen right there. Yeah. Now, one more for you, Hal. What is it like to be appointed by President Carter to go be U.S. Attorney and then have to recuse yourself from one of the biggest cases ever tried in Tennessee?
It was difficult. I still remained involved in certain things, such as the final days of the Blanton administration when I decided I had to do something. But it was frustrating. But I had a lot of faith in Aleda and Bob.
I was going to ask you if you could tell us a little bit about your decision to pick those two to do that case.
Well, Aleda has all of the quality. To me, she is one of the real pioneers for female lawyers in this town. She was bright. I always thought she'd be governor or president or whatever. And Bob Lynch at that time had tried a lot of cases across the country for the Department of Justice. They were both very good and hardworking people, and it's shown by they tried a very, very difficult case, and they won it, and the proof's in the pudding.
Now, Joe, at the same time, they're in one courtroom trying the governor, you're down the hall trying Benson, right?
Right. During the course of the investigation, Bill Cohen and I and Hick Ewing, who was the first assistant over in Memphis, and the U.S. Attorney over there had also recused himself. So the two first assistants in Memphis and Nashville were trying the cases, and we signed the indictments. But Bill and I were working on it, and we were up to our keisters in alligators in the pardons and parole case, and we got the information of the liquor license, Ham coming in, and so we looked around the office, and you got to remember, this was a pretty small office. We had 10 attorneys total, and so it was a small office. And looked around. Bob was the most experienced prosecutor that was available. Leda was going to work second chair and also had shown great promise. So the decision was made they would take over the investigation of the liquor licenses and handle that. And so they ran with that case because Bill and I were totally tied up. And so, that's 40% of the office right there, tied up on two cases that are going to run as they did. Two of the longest, the first trial, we went, 4 weeks before Neese had his heart attack. And we went 4 weeks on the trial of that and came back for the subsequent trial. And they had their trial. So those were, at that time, I think probably the longest trials, maybe except for one fraud case that we'd had in Middle Tennessee.
The clerk's case.
The clerk's case was, I don't know, how long did that take?
4 months.
The trial?
Yeah.
That was longer then.
Now, all of you,
to take that much time.
all of you knew, and two of you worked for one of my favorite people, Tom Shriver. And Tom obviously led the way in the prosecution of Eddie Shaw and missed, although he did get a conviction in McCarter case, obviously. What did you all think? Both of you, I know, were very close to Tom at that time. What did you think about Tom's decision to indict Eddie Shaw rather than maybe hold back and get more proof or take it federal or whatever? Did either one of you have any thoughts about that or possibly any conversations with him about that?
Go, Hal.
Well, I mean, we all loved Tom Shriver, no question about that. We all have our faults. I think one of Tom's is he sometimes would pull the trigger too fast. Yeah. He was a go-get-'em kind of guy, and he wanted to try the big cases. And sometimes I thought he acted a little too hastily. But he was a good person, great DA. Couldn't ask for anybody better.
Yeah, a great DA, but maybe not the greatest trial lawyer in the office. I mean, that had something to do with the Powell case, didn't it?
Well, it did.
Yeah.
That's the reason that Mr. Jack Norman Sr. waived his final argument.
Right.
Because Tom had given a very methodical, very long, detailed, dull opening statement. And at which point, Jack Norman Sr., being one of the great trial lawyers of all times, told the defendant and told his co-counsel, I'm going to waive juries. I'm going to shut up. Because he said...
Big moment.
It was a big moment. He said, he later told me that one of the reasons he made that decision was, he said, John Hooker Sr. was probably the greatest orator of all times, and I agree with that. He says, my good friend Cecil is going to get up and give a good argument as co-counsel, and then they're going to break for dinner, and all of a sudden they're going to be introduced to John Hooker Sr. on a full belly. And there's no way that they're going to let this man go after Hooker argues. And so he stood up and said, I will not argue. Charge the jury.
We have about 5 minutes left, and I wanted to reserve that time for the panel's members. If there's anything that you feel like we have not covered or anything that we've missed, been wrong about, or anything that you want to say, I'd like to give you that opportunity now in the final minutes of our program today. And anybody that feels led, just pipe up.
Well, I don't want to seem defensive, but I do, to go back to the business about being appointed a judge by somebody who then ended up in the federal pen, I just want to mention that in addition to Hal Hardin, early on in the whole Blanton term, He appointed people such as John Nixon, Bob Brandt, Alan Cornelius, he elevated to the Court of Criminal Appeals. He appointed A.A. Birch to the circuit level, or I guess the criminal court. He made 2 additional appointments of African-American judges down in Memphis, which was really groundbreaking, and appointed Herschel Franks to the Court of Appeals, John Byers to my court. I mean, it was just a series of really solid judicial appointments, and so if that sounds a little defensive, I'm sorry, but I just wanted to drop a few important.
I'm glad you. I was going to ask you if you knew the names, but I hadn't checked with you, so I was afraid to do that. Good. Anybody else? Final thoughts? All right. I've got one more video that I think we will close with, number 8.
Well, let me say this. I've not said a lot over the years, and I think you need to put this in there. I've never said a lot over the years because the experience that I went through was so horrible that my dear wife, who passed away a year ago yesterday, I tell you, she was afraid that if I raised my voice at the mall that I was going to get arrested. She didn't want to hear anything about this. She wanted to play like it never happened. But that's always been very, very, very difficult for me to do. And but that is the reason why I have not said a lot over the years in respect for her.
We always have to remember as lawyers and judges that the cases that we work on, the cases that we try, have an impact on human lives. And what we've tried to do today is give you about 3 hours and 15 minutes of what at the time was high drama, but it had an impact on individual lives like Eddie here, and it also had an impact on the life of our entire community and state. There will always be corruption as long as there are people. But the response to that corruption is the way the community and the law enforcement community and the judicial and legal community will be judged. And I hope you agree with me that in terms of the Blanton years, even though there were some misfires and there were some mistakes along the way, the legal community in Nashville responded in force, well and intelligently, and by all these folks still being around today to be able to tell about it, there's some longevity involved as well. I hope you will join me in thanking them for all of the hard work that went into that. Don't forget to fill out your forms before you leave.
People like you and me. He's a man of all the people. He'll treat us fair and equal. We need a ray of Blanton sunshine. He's the Democrat for our future, our man for the governor's chair. Young or old, black or white, he listens 'cause he cares. His record speaks out loudly. For years he served us proudly.